So is that. Thank you. Good afternoon, everyone, and welcome. I'm going to call this April 14th meeting of the Community Safety Standing Policy Committee to order. Mr. City Clerk, could I please have a roll call?
Thank you. Members of the Community Safety Standing Policy Committee, Councillor Campbell.
Present.
Councillor Middleton Hope.
Present.
Councillor Parker.
Online, thank you.
Deputy Mayor Schmidt-Rempel.
Present.
All members of the Community Safety Standing Policy Committee are in attendance, and we have quorum.
Thank you very much. I will start with the acknowledgement statement. The City of Lethbridge acknowledges that we are gathered on the lands of the Blackfoot people of the Canadian Plains and pays respect to the Blackfoot people, past, present, and future, while recognizing and respecting their cultural heritage, beliefs, and relationships to the land. The City of Lethbridge is also home to the Métis Nation of Alberta, Region 3. Could I please have a motion to adopt the agenda of today's meeting? Councillor Campbell? All in favor? Do we have any opposed? Seeing none. Moving on to the consent agenda. Could I please have a motion, be it resolved, that the minutes of the Community Safety Standing Policy Committee meeting held on March 10th, 2022 be approved and the Mayor and City Clerk be authorized to sign the same? Could I please have that motion, please? Councillor Campbell? Do we have any opposed? Middleton Hope is opposed?
No, I had my hand up to support the motion.
Okay.
It's just slower at this end.
Got it. All right.
You know, that broadband.
We're working on it. So we do not have any presentations today, but we do have some submissions. First submission we have is submission 6.1, Dwayne Enns, General Manager, Regulatory Services, regarding the proposed public places bylaw. Do I have any members of council who have any questions for Mr. Enns with regard to that?
I do, Madam Chair.
Go ahead, Councillor Parker.
Maybe I was going to ask Councillor Milton Hope, you sent out an email regarding some of your viewpoints on this. Did you have any questions, or what were your main concerns? So I know you sent an email.
Yeah, thanks, Ryan. I was just simply addressing the concerns that were identified in the report regarding Section 9 and Section 10.2 E as an echo. And so I simply addressed those and sent them out for people to have a look at if there was any need for additional discussion or if we wanted to provide that to the author.
Thank you, John.
Thank you very much. I guess my question would be with regards to those changes, Mr. Fox or Mr. Enns, should we be having Councillor Middleton Hope outline what those changes are for the public hearing?
That would probably be a good idea. I know that some of these were discussed at our lab, but maybe for the public hearing. Through the chair, I think what Mr. Enns was saying is that it would be a good idea if Middleton Hope would like to do that for the committee and the public.
Thank you. Councillor Middleton Hope, can I please have you outline what those changes are so that the public can have an opportunity to hear those as well?
Certainly. I think if I'll reference Section 9, there was a concern in regards to the language that was used within the document. And so what I've done is I've gone to common definitions for anti-street harassment as well as harassment under the Criminal Code of Canada, and I've provided some of those pieces of, some of that documentation, and then I've provided a proposal at the bottom which manages the language a little bit differently, and so it would be I guess to the author, which would be Mr. Enns, I take it, just simply changing some of the language around to address the concerns that were voiced through the process of developing this particular bylaw. So if Mr. Enns could have a look at it, then perhaps he can provide some indication to the committee whether that meets needs of the individuals that that provided some feedback on it. If so, and if the indication is that the information is acceptable, great. If you want to change it, by all means. It's just an opportunity for additional dialogue in that regard. So what I basically said in regards to Section 9 is that replacing the section that is contained in the bylaw, the proposed bylaw, with no person shall, without lawful excuse, repeatedly communicate, either directly or indirectly, with another person in a public place without consent for the purposes of intimidating, threatening, menacing, bullying, terrifying, or alarming that person, rather than the language that was used, which seemed to be a little bit more specific. This is perhaps more generalized. And then the second section, which I went on to have a look at, which was Section 10, subsection 2, subsection E. And I would ask Mr. Lowen to have a look at that section as well. There was some concern in regards to a person having to be perceived to be under the influence of alcohol or a stupefying substance. My concern with that language reflected that of the members either of the public or of other committees who said that that seemed to be problematic. And so my comments are that proof of intoxication or stupefaction by a layperson may be difficult to prove and articulate any indicia of impairment. Therefore, I would remove Section 10, subsection 2, subsection E. And those are my thoughts on the bylaw.
Thank you very much, Councillor Middleton Hope. Mr. Enns or Mr. Lowen, do you have feedback or comments that you would like to provide at this time?
I can make a couple of quick comments, and then City Solicitor can join in. I'm going to first turn to Section 10.2E. And yes, at RLEC, there was a number of concerns brought up about intoxication and whether or not one or two, let's say, beers would meet that definition. It won't. However, there was also discussion at that meeting, especially from Inspector Walper, who indicated that there are other sections that can deal with this, and the police services did not have any major concerns with removing that section. So from at least our point of view, we don't have a concern if that particular section is removed. I don't know if City Solicitor wants to have anything to say on that particular section.
No, I think that's, you can include it or not include it as you wish, and would agree with the comments that Mr. Enns made.
Good. I'm going to turn my attention to the other section. And the section we're referring to, just so that everyone who's watching knows, there's a list of antisocial behaviors listed in the bylaw. And under Section 9, Sub 2, the section that people had concerns about mentioned that person shall not act in the manner in a public place that causes another person reasonably in all the circumstances to feel harassed, troubled, worried, or badgered. So the section, I believe, and correct me if I'm wrong, the proposed amendment to that section would be no person shall, without lawful excuse, repeatedly communicate either directly or indirectly with another person in a public place without consent for the purpose of intimidating, threatening, menacing, bullying, terrifying, or alarming that person. And thank you, City Clerk, for handing these to me prior to the meeting, so we had a chance to take a look at it, and I did discuss it just briefly with the City Solicitor. The one concern on that, and most of the section is quite fine, is I think surrounding the words the purpose of intimidating and threatening. Most or all bylaw offenses usually are strict liability offenses where I don't have to prove mens rea being a guilty mind. And in this particular section, when it says for the purpose of intimidating, it brings it into having to prove or put evidence forward of a guilty mind in this particular sense, and it might make it a little more difficult to prosecute that. But I don't want to get into the sections. It's not my job. I'm going to let the City Solicitor have any comments that he might have on that particular section.
I'd start by agreeing with Mr. Enns that the language seems to be broader in the sense of requiring some intent on behalf of whoever might be charged. The other thing that's missing from the proposed language, Councillor, is the phrase that we included in the draft that you have in the package, which talks about ensuring that the court would have a review of what's reasonable in all the circumstances. We really want to, at these kinds of sections where there's perhaps some subjectivity or call for interpretation at times, the wording of the section is designed such that both you need the person who's feeling victimized to legitimately feel that they actually feel threatened, not that they weren't threatened, and that feeling is reasonable in all the circumstances to sort of balance everyone's interests. And I think that's that objective lens is what's missing from the language that's proposed on the screen.
Councillor Middleton Hope, did you have any response or have any
Yeah,
questions?
so to Mr. Lowen, through the chair, well, Brian, it's clear that there was some concern, and that's simply what I was trying to address by that. Would it be more palatable? I mean, first of all, do you have any concerns with the language? And I think it was feel that people had some umbrage with. If that doesn't cause, from a legal perspective, any concerns, then both of them are fine. I was just simply trying to respond to the concerns that were voiced in regards to the language of the two sections. So it's not that I'm proposing that we simply change the sections because I felt the language was inappropriate. I was simply responding to the concerns around the language, and I think the language specifically spoke to the word feel. If that is the case, then would something along the lines of the Section 9 proposal, without consent, intimidate, threaten, menace, bully, terrify, or alarm another person? Would that satisfy you, or are you satisfied with the way in which it's worded currently?
First of all, I'd say I wasn't present at the RLAC committee meeting, and so I don't have a very good sense of what the precise nature of the concern was. My next point would be that we looked very carefully at sections 1 and 2 to think about, again, the requirement both for there to be a subjective feeling of being harassed and for that to be objectively reasonable in all the circumstances. And that objective piece is really for the protection of people against misunderstanding. So I'm at a bit of a disadvantage in that I don't know what the concern was there. In terms of which particular synonyms council wants to choose, I would only make the observation that harassed, fearful, troubled, worried, or badgered seems to be a lower threshold than what's proposed in this language, where the words are intimidating, threatening, menacing, bullying, terrifying, or alarming. And without having much time to consider it, I'm always leery of approaching language that is closer to the criminal jurisdiction of the federal government and therefore possibly risking somebody arguing that the municipal bylaw is too close to or infringing upon the criminal law power. But again, I haven't had the time to think that through. I've just seen this language on the way into the meeting. But those are my thoughts.
Mr. Fox, you have some comments you'd like to make?
Through the chair, at the RLAC meeting, I believe that the intent of the committee was about who feels it. It wasn't being thought of as feels as a legal context. And it was from us lay people that aren't actually using it to incriminate. And it was more about how the purpose of the bylaw would be enforced, I believe was the concern, not actually how the bylaw was written. That was in the conversation what I took out of it, and what it was trying to do is limit, or could we handle how it is enforced? And Mr. Wahlberg at that meeting did explain that the bylaw would only be used as a last resort to address issues, and that the LPS take many other efforts to resolve an issue before actually relying on the bylaw. And what we said is when we went away, we would look at both of these sections, and we do deem that feel is necessary and needs to be in there from a legal perspective, and just for extra information there.
Thank you very much, Mr. Fox. Councillor Campbell?
Thank you, Madam Chair. Just let's just kind of go back to the intent of this bylaw and just sort of make sure that we know why we're here. I know you kind of alluded to it, but I just want to have clarification because I know for me as someone who's not up on the law, like a lot of this does seem to be semantics. And do the words, I mean, words matter, but do they really matter in the context of trying to enforce this bylaw?
Actually, well, I'm the one person who really cares about the wording of it, because when you take it into court, and there's actually someone, pleads not guilty on one of these, it's up to the Crown to prove every element of the offense, and every word in the section has a meaning, and you have to prove the exact section and present evidence to prove it. So yes, little words like that do have a big difference when it comes. I have lost cases over one word or one comma being in the wrong spot, and I've come back and we've changed and we amended the bylaw, but it is fairly particular when it comes to wording of these particular bylaws.
And if I can add to that too, the reason why this bylaw is coming forward is that in the streets bylaw, the section was removed. So we need a public spaces bylaw. We just expanded it. Now it covers parks and other public spaces for these activities, where in the streets bylaw, we didn't feel that that was the right place to have that in there, because it was only directed towards streets.
And just to add to that as well, the working group that looked at that, in addition to the fact that they wanted to take some of this out of the streets bylaw, it's common practice in a lot of municipalities to have these in a specific bylaw set aside, so you can also educate individuals what are the expected behaviors and the like. So they thought that it would be a good idea to have a public spaces bylaw, take some of the sections out of the streets bylaw that aren't specifically related to streets, add a couple other sections and present it so that we can promote good behavior in the community. And
you also explained that the intent of the bylaw wasn't necessarily to start writing tickets, but just we want, I mean, and so the chance of prosecution with this bylaw is somewhat, I mean, it probably isn't high.
It's not going to be that high. I had the occasional ticket under the streets bylaw.
You were panhandling? Sorry.
The one I could really remember is a couple of young folks with their skateboards going in and out, and we're told, to stop. I think they were using pedestrians as obstacle courses or whatever, and eventually the police said, we're giving you a ticket. You're not listening to us or whatever. I mean, I took it all the way to court. Unfortunately, I did get a conviction in that case. Unfortunately, the ticket was only $25 each. So that's also reflected in here. There's a $300 ticket for each of the offenses, which brings it up to a more reasonable fine.
So, I mean, going forward, for me, I'm just, and I don't know how Councilor Middleton Hope, I'm comfortable with how you interpret it, how you want to do it, and what our solicitor does. And Councilor Middleton Hope, where are you in trying to move this forward?
Thanks, Councillor Campbell, for that. And to Mr. Enns, I just simply speak to the engagement portion of the report I guess it's the report that you submitted in regards to the proposed public bylaws, places bylaw, in which you indicate in here, it says that there were some concerns by City Council members with respect to two sections of the proposed bylaw. Firstly, Section 9 and the use of the word feel. Secondly, with respect to Section 10(2)E and whether this section is needed. So I simply draw your attention to those two sections. I'm not trying to suggest that my proposal should supersede yours. I was simply responding to the fact that two council members had attended that meeting and had some concerns. That's why I've addressed it in this manner.
Yeah, through the chair to Councillor Middleton Hope. Oh, yeah, no, and I do appreciate what you've done on this. Yeah, there was two concerns. So, we talked about the one concern about the intoxication section. I believe if people were a little uncomfortable with that, and like I said, police services indicated that there's other sections they can use, and if that is removed, that they didn't think that would be a big issue. We just kept it in there because there was some discussion about whether intoxication meant having one beer. So we just wanted to have the discussion here. No, it doesn't mean one beer. It's a little more than that. But I don't think there was a big concern of removing that. So if there's an amendment to remove that section, that's fine. And the other one, yes, individuals had concerns at the time about the question feel, but in discussing it with the city solicitor, and him pointing out to me that actually taking that out would make it a lot easier offense it's something that should be in there so that it isn't such an easy thing to go after an individual on. You have to reasonably feel harassed. You can't just be just too sensitive to something, and that's the reason why that section was in there. So there was discussion at RLAC. We went back, we reviewed the section, and in discussions, I don't want to put any words in the city solicitor's mouth, but we indicated that, yeah, I can see where people would have a concern with that section, but that section we felt was properly written. And yes, no, so I appreciate you bringing that up, and that was two of the big issues that came out of the RLAC meeting.
Thank you very much, Mr. Enns. I'm just going to ask Councillor Middleton Hope, are you wanting to make amendments to this bylaw now, or would it be fair to say that we could move forward with it as it is to the first reading, bring it to council, and then if there are amendments you want to make at that time, you can make those during the second reading and we can discuss them as a whole body of council?
Yeah, I think I'm certainly satisfied with what Mr. Enns has to say and understand the spirit in which I've made these proposals. The one thing that I would ask Mr. Enns and or Mr. Lowen to reflect on is in regards to the intoxication rather of subjects that might be reviewed or viewed by the application of this bylaw. There's a whole lot more than just intoxication. There's stupefaction from all kinds of intoxicating substances. So if you're satisfied that this covers that, then fine. I wouldn't want anyone who would be in a position to enforce the bylaw to have to determine whether or not it's alcohol or glue or gasoline or some other paint thinner or other substance that's being used by a subject. And then have to get into some kind of an argument around that language. So I think at perhaps at a, I wouldn't say at a minimum, but perhaps it might be given some thought to removing that section 10 to E at a minimum, and then let's move this thing forward.
So would you like to make that amendment now, Councillor Middleton Hope?
I think if Mr. Enns and Mr. Lowen agree with it, if not, if they want to keep it in, then let's just move the bylaw forward as it is.
Mr. Enns and Mr. Lowen, would you like to respond, please?
I have no objection at all to removing it.
I have no objection, and anecdotally, I would just say, generally, the easiest way that if you needed to have a prosecutable ticket with that language, it's going to be the repeated communication that creates the aggressiveness, and there's no need to rely on something like intoxication. So it's, I think practically speaking, it's easy to pull out as well.
Okay, so we'll be moving that, that point 10 to E then. Is that your amendment, Councillor Middleton Hope?
Yes, thank you, Madam Chair.
Okay. Is there any further discussion around this? No? All right, then I have a motion here from Councillor, oh, hang on, David's going to give me. Okay, so I have then a motion from Councillor Middleton Hope. Be it resolved that the Community Safety Standing Policy Committee recommends that we remove section 10.2.E from this bylaw. Bylaw 6280. Any further discussion? Councillor Middleton Hope, did you have any further comments to make on this?
No, Madam Chair, we can just call a question if you like.
All right, we'll call the question. All in favor? Do we have any opposed? All right. Okay. So now I have a second motion by Councillor Middleton Hope. Be it resolved that the Community Safety Standing Policy Committee recommends that Council, 1, receive the report and file as information, and 2, recommend that Council give the Public Spaces Bylaw as amended first reading. Councillor Middleton Hope.
If there's any debate,
Nobody's
hearing none.
All right, we'll call the vote. All in favor? Do we have any opposed? Nope. All right, that carries then. We're moving on to submission 6.2, Dwayne Enns, General Manager, Regulatory Services regarding the light nuisance report. I do not see anybody on the audience who would like to speak to this. So do we have any members of council that have any questions with regards to the light nuisance report? Councillor Campbell.
Thank you, Madam Chair. Just Mr. Enns, I know there was concerned community about some issues. I believe there was some ecological issues about too much light, as in harming bees, and I think some other, if memory serves me right. Is this addressed in the new in the bylaw that we have here at all, or did I miss that? I think there was something about.
No, it wasn't addressed because we didn't get the expertise. And I must add, though, that I'm also joined by Maureen Gehring of GM Planning and Design, and Richard Brumman from Road Infrastructure Manager, who helped me put this information together. I don't believe there was any expertise at the table to properly advise council on the loss of bees or loss of insect habitat. So that wasn't put in the report, sorry.
Well, it's fine. And I don't know how big of a concern it actually is. I mean, I don't know if there was any research done on that. Probably not.
No.
Especially in Lethbridge anyway.
Well, there wasn't, sir.
Okay, thank you.
Mr. Fox, did you have something you wanted to add to that particular comment?
Yeah, if I could, through the chair. There is a lot of dark spaces in Lethbridge, including the River Valley. We also have an area around the observatory that has no lights pollution in that area. Most of the other lights on our infrastructure part are for public safety, road acts, stuff like that. And then what residents use are covered under our land use bylaw. And people do illuminate areas that may be habitat, but then we don't force people to make habitat for animals at their houses. So that's sometimes the hard part. And where do we draw the line on how we try and protect certain types of species? And I believe if council's wish was for us to dig into that more, we would need some direction. And we could probably get a biologist or somebody involved if you would like to address that further. But in administration's point of view, I believe that we felt that there is enough habitat around, in our view, with trying to balance the needs of nature and all the other aspects of why we light streets and residents and stuff like that.
Councillor Middleton Hope.
Thank you. Through the chair to Mr. Enns. First, I want to compliment you and your staff on the report. It's really well articulated, and so thank you for that. Also mentioning that the lighting is contained in the land use bylaw. I'm just wondering if the bylaw and the report provide citizens and regulatory options to address. So does our policy include what we tell citizens align with what's contained in the report? Specifically, I will reference the area in which you're talking specifically about Section 59 and the strategies that are utilized by presumed regulatory services. Are these strategies that citizens are encouraged to use before contacting regulatory services? And if so, then do they align with what we're telling them?
Actually, that particular section, that's a land use bylaw, so, and it's enforced by planning and design. I don't know if Maureen has any.
You indicate here that it's, I presume it's a development officer that does the review?
Yep, Ms. Gehring is here to speak to that.
Okay.
Good afternoon, Councillor Middleton Hope. Yes, on applications, the development officer does do a review for lighting. One of the other things I'd like to point out is our development compliance officer has only had a couple of complaints within the last 4 years in regards to lighting. All of those have been resolved through just speaking with the owner of the business or owner of the property just to understand the complainant's point of view. So we've never had to issue an order or anything. We do try to work these things out, and usually people are pretty understanding. They usually don't realize how they've impacted their adjacent neighbor.
Thank you for that through the chair. I was just simply reflecting on do we provide feedback to citizens who call in to complain to try and resolve the issue themselves, which is aligned with the information contained in this report, or do we simply then handle it from either a developmental or a regulatory perspective?
So if we do get a complaint, our development compliance officer does follow up. We don't usually just say to the person, you know, go talk to your neighbor. We will do some inquiry and work that out ourselves for them.
Okay, so they're clearly a part of the process then.
Yes, that's correct.
Good, thank you.
Do you have any other questions or comments with regards to the light nuisance report? All right, seeing none, I have a motion here. I need someone to move, please. Be it resolved that the Community Safety Standing Policy Committee recommends that Council receive the report and file as information. Could I please have a mover?
So moved.
Councillor Middleton Hope? All in favor? Do we have any opposed? And that's carried. On next to the spring 2022 hazard reports, we've got Luke Palmer, Emergency Preparedness Manager, here to discuss that. Do we have any members of council with any questions with regards to this report? Any questions? I'll give you one more chance. Nope, seeing none. Oh, Councillor Campbell?
I was just going to say thank you for presenting the report. As always, great job. Thank you. That was it.
Okay.
I guess not a question, sorry.
Councillor Middleton Hope, I see you popping in.
Well, I'm moving my finger over the raise your hand button just as quickly as I can, but you're moving faster than I can do it. This is a question to Mr. Palmer. Are we considering water rationing as part of mitigation strategy this summer? Particularly in light of the fact that we're looking at a smaller or a more shallow snowpack, as well as less rain, although there is forecasted, I think you indicated in your report, in May and June. But are we considering water rationing and as a mitigation strategy this summer? And I have a second question for you after you handle that one.
Thank you, Councillor Middleton Hope. For the most part, I think realistically down here, we consider that yearly. And we do have the water rationing plan in conjunction with utilities in the city, other departments. We would look to see what kind of trigger points would require that implementation. I'd like to say that we're ready for that, just seeing the last 3 years we've been in this drought situation. So while it's not actively being considered for use right now, it's certainly something that we actively consider throughout the year in our monitoring.
Good, okay, well, thank you. And then my second question is in regards to release of water from the dams upstream. And I'm familiar with working with the Alberta Environments and Parks on the strategy of water management, but are we closely working with them? We've had some difficulty in years past in which significant flooding occurred down in the river valley, in part because of obviously a heavy snowpack and water, but also part of it was dam management. And so are we continuing to work very closely with Alberta Environment and Parks to manage that?
Certainly, and the timing of this is perfect. We actually just received notice, actually updated plans from each of the 5 dams in the region this week. So we've added that to our inventory. Not only that, with the sharing of plans from Alberta Rivers, we also are invited to an open house where we actually get to the Old Man Dam. We get to collaborate and see what they're actually monitoring in terms of the snowpack specifically. So that open house is a quick roundabout way of seeing what the plans are and in terms of any changes that have occurred. But also they bring in members from Alberta River Forecasting to say, well, this is what we're actually actively looking at in terms of the snow pillow and the pack that is there. And it is higher than we would have seen in previous years. Currently, what we've been told is this year looks very reminiscent to 2013 in terms of the snowpack, plus the potential cold lows. So it could be quite similar to that, and we're quite excited that they've been preemptively in touch with us. So I do believe that that collaboration is going to allow us to be in a state of readiness and continue to monitor that. But it is something greatly on our radar right now, and the timing is perfect because they've already reached out.
I'll rely on your knowledge, Mr. Palmer. If I'm not mistaken, 2013 was the last year in which we experienced significant flooding down in the river valley. Is that correct?
That is the same year, yes. So we're going to be definitely monitoring. Obviously, right now everything is what we're seeing currently outside is in alignment with what they've told us. So right now, during the month of May and June, it's very much monitoring, seeing what's happening with the snow pillow and everything else, and the temperatures that we do have. The forecasted temperatures are in our favor, conversely, in terms of what 2013 yielded. We had higher temperatures in the spring, which caused the rapid melt. This year, it looks like it could be a little bit more delayed. So this is the monitoring phase, and we're quite ready for that.
Good. I would like a couple of hours' notice if I have to turn my house into an ark. So if you can provide that, I would appreciate it. Thank you.
Thank you very much, Councillor Middleton Hope. Does anybody else have any questions for Luke? All right, seeing none. Could I please have a motion here? Could I please have somebody move? Be it resolved that the Community Safety Standing Policy Committee receive the provided summary and presentation as information. Could I please have a mover on that?
So moved.
I'll make.
Oh, I got in.
Go ahead, Mark. Go ahead.
I saw Mark like with his hand over that button. Councillor Campbell, all in favor? Is there anybody opposed? Seeing none, that carries. Thank you to everyone who brought their submissions forward today and answered all of our questions for us. That was great. Thank you, everyone, and I will call this meeting closed.
Thank you. Take care, everyone.